Hello there, my name is Paul Campbell, and I'm going to continue to read You Know Something is Wrong When, an American Affidavit of Probable Cause. And today, we will be reading Part 5, Getting Organized. So, when you get mail addressed in the form of John Quincy Adams, or John Quincy Adams, or John Q. Adams, or John Q. Adams, you can rest assured that it is not addressed to any American state citizen, and it is not addressed to the living man, even if that does happen to be your appellation. Darn it all. What's going on with all this misaddressed mail? King George still doesn't know who I am? I don't know what to tell you, John. After all the trouble you've caused, I'd expect him to know it by heart. Must be mail fraud. Articles of Confederation, the First Act, 1781. While most people think that confederation means a loose association of states created for their mutual benefit, there is a darker meaning to the word familiar in criminal law. A collusion of self-interested parties to the detriment of others. In that sense, those who sought to create a national government via the Articles of Confederation and those who later created the Constitution for the United States of America were criminals acting against the interest of their home states. Naturally, the organic states possessed air, land, and sea jurisdictions. The Articles of Confederation, which created a perpetual union of the states, created an unnatural superstate so that the jurisdiction could be split, with the states retaining the national level jurisdiction of the land. And the new entity, which was to become the federal government, could have control of the international jurisdiction of the sea. This loss of the international jurisdiction was arguably a loss and detriment to the states, especially in that it created two masters, the states on the land and the federal government on the sea, and made the current dilemmas inevitable. It's a hot time in old Philadelphia. In the space of only 2 years, 1787 to 1789, two new nations and two national trusts were formed. For the American colonies, acting under the perfected 1787 Supreme Republican Declaration of the United States of the United American Colonies, there was the United States Trust, 1787, and a new nation based on landed estates. This is the land trust owed to the organic states of the United Colonies, which underlies everything else. The actual name of the new nation was, and is, States of America. United was just an adjective used to describe their affiliation, but this entity is better known as the continental United States. Next, the United States of America, Federal United States, was created and defined by the Constitution for the United States of America, and the United States Trust, 1789, was set up to receive the assets granted to the federal government. Much later, a third national trust, the Public Charitable Trust, was set up by the corporate United States as a welfare fund to mitigate the suffering of Negroes displaced by the Civil War. This eventually morphed into the Social Security Fund. According to the 1824 Webster's Dictionary, the word federal was a synonym for contract at the time. So federal government equals contract government. All constitutions are contracts involving debt. In this case, the debt the American states incurred as a result of creating the federal government and agreeing to pay for the services it provided. The Condo Association. Think of it like a condo association. Each of the estates had their own land and sovereignty, yet they were all condo association members. There were certain tasks they either couldn't or didn't want to do for themselves, like raking leaves and mowing lawn, snow removal in the winter, security all year long, garbage pickup, appliance maintenance, and so on. So they hired those 19 enumerated powers out to the federal government. At the time, the Americans had no navy, only a commercial fleet that was easy prey on the high seas. The British had the best navy in the world and a desperate need for American raw materials. It was natural to strike a deal allowing the British to manage the jurisdiction of the sea and provide protection for American shipping. They made several treaties promising perpetual aid, friendship, and amity for the Americans, guaranteed by the British on the high seas and inland waters. In addition to the United States of America and the separate foreign entity operating the jurisdiction of the sea as the United States of America, there's a third party on the stage. 1790 Follies. The United States, a foreign for-profit investment company, which under the leadership of its president, George Washington, is about to start supplying 19 enumerated services to the American states under an equity contract known as, drumroll, the Constitution for the United States of America. The Office of President. The Office of President is and has always been a company office, and later a corporate office, not a head of state. This is because the separate states are each sovereign nations acting for international purposes as a federation. The Ohio State is part of the Confederation of the United States of America, aka continental United States. In the same way as Bulgaria was part of the old Soviet Union. There are actually three presidential offices: President of the United States of America, major, on the land, President of the United States of America, minor, on the sea, and President of the United States, municipal. This is how Abraham Lincoln and Barack Obama, both of whom were/are ineligible to serve as President of the United States of America, major, are nonetheless able to serve as President of the United States of America, minor, and as President of the United States, municipal. Here is the actual definition of president from the 1856 version of A Law Dictionary adapted to the Constitution and Laws of the United States by John Bouvier. President, an officer of a company who is to direct the manner in which business is to be transacted. From the decision of the president, there is an appeal to the body over which he presides. Today we would recognize this office as a chief executive office. The actual Constitution creating the federal United States and delegating the international jurisdiction of the sea to it names the president commander and chief of the armed forces because he is responsible for defending the states from attack by foreign countries and may also be called upon to settle disputes between states over a variety of federally controlled issues, including interstates, commerce. Commerce is a business conducted between corporations, including the federal states of states, like the state of Ohio and the state of Indiana. Corporations accrue income, hence the income tax. Trade is business conducted between people, associations, sole proprietors, simple partnerships, pure trust, and other unincorporated business structures. These entities accrue private property, not income. President number one. The president's duties under the actual Constitution pertaining to the continental United States have never changed. His job is to determine how, not what, when, how, much, where, at what cost, or why business is conducted. That is the business of the members of Congress, when and if they act as deputies, accountably fiduciary officers of their home states, like the Ohio state and the Wisconsin state, and convene a Continental Congress. The president's job with respect to actual states on the land is purely executive. He figures out how to do what the state deputies tell him to do, and the state deputies are directly accountable to the people, House of Representatives, and to the actual state legislature, Senate. Please note that the Ohio State Legislature, Continental States, is not the same as the state of Ohio legislature, federal state. President number two. The president's duties under the similarly named Constitution of the United States of America pertain solely to the affairs of the federal states that operate in the international jurisdiction of the sea, including the states of states, like the state of Ohio or state of Ohio, or most recently, Ohio and their franchises. He has more power in this role, but is still limited in that the federal Congress acts as his board of directors, holds the purse strings on the federal budget, and so on. It is in this capacity that he introduces, lobbies for or vetoes federal legislation. This is all in House and only impacts federal states of states, like the state of Iowa, other federal corporations, federal territories, and United States citizens. President number three. As President of the United States, a corporate CEO acting under the Constitution of the United States, no, of America about it, he has been given dictatorial style power and can run federal functions by executive orders issued to the federal municipal franchises incorporated under the laws of the Washington, D.C. municipality, an independent international city-state. The Washington, D.C. municipality has no actual authority outside of the physical boundaries of Washington, D.C. with respect to the continental United States, despite gross pretensions otherwise, and the president acting in this role has only the powers of any other corporate CEO. The Washington, D.C. municipal government has created hundreds of millions of citizens for itself named after living Americans and American cities and towns, and claims to own and operate all these franchises as chattel property. These are all United States citizens, debt slaves, which exist only on paper, but which are used as devices to promote fraud against actual people, towns, counties, and cities. So what is the Constitution? It is a two-part equity contract consisting of a trust indenture preamble and Bill of Rights, and a services agreement contract. It obligates the United States Commercial Company to provide certain enumerated services, including protection of the national trust, and the subscribing states agreed to pay for all of this. No wonder United States citizens are so eager to defend the Constitution from all enemies, foreign and domestic. It's their meal ticket. American state citizens have a different view of it, that of increasingly disgusted consumers. The third phase of the Constitution. As a document, the Constitution for the United States of America is straightforward: a trust indenture and a services contract. But there is another aspect to it that is a matter of function rather than form. The Constitution, the real one, is a trilateral international treaty. 1. It binds each state to the federal union. 2. It binds each state to the other states. 3. It binds the states as a group to the federal union. Another important point to note is that all parties are acting in international commerce. Each state of America is for the purposes of international law a separate nation. So the Constitution represents a solemn treaty among many nations, a solemn treaty among many nations, obligating each to provide services or sustenance or both for the others, all of them interconnected according to the terms of the agreements reached. Other important facts to know: not all the original 13 colonies signed on to the Constitution. Only nine originally ratified it. The rest joined the Union at a later time, and new states were added under the Northwest Ordinance and the Equal Footing Doctrine for almost 100 years, right up until the Civil War. With the Civil War, the country entered a crisis that is still not resolved. As a result, no true American states, known as States of America, have been added to the federal union since 1860. All the states which exist in the western half of the United States of America are now really states of America under the Northwest Ordinance, because there has been no competent Congress convened since 1860 that is able to grant them such status. Instead, these states have been operated entirely as federal states and treated more or less like real states of America under separate compacts or trust that agreed to honor their incipient land jurisdiction as if they were true states of the land. Please note that the people are not direct parties to the Constitution and have only second-hand subrogated standing. The states and the federal union are the direct parties obligated by the contract. Also notice that the Constitution is not the source of any of your rights and material interest. Instead, it restricts the federal union and limits it and provides guarantees protecting rights and prerogatives living people already have. Pick a constitution, any constitution. Step right up. 1. The original equity contract, known as the Constitution for the United States of America, which created the federal United States, is built of articles of treaty. Amendments are slight changes or interpretations of the treaty made by agreement of the subscribing parties. There are 10 articles and 3 amendments to the original equity contract, including one known as the Titles of Nobility Amendment Tona, which does not appear in the corporate constitution published by the United States of America, incorporated circa 1868. Tona made it explicitly impossible for members of the Bar Association to hold any public office because they were in receipt of a foreign title of nobility, esquire. Amendments to the original equity contract require a properly seated Congress composed of deputies representing the landed estates and a lengthy ratification process by each state legislator operating in fiduciary capacity as state delegates, deputies. Delegates. Because neither the Congress nor the state legislators have been operating in their proper capacity, no amendments have been made to the actual Constitution since 1860. This is the actual Constitution that establishes the law of the land. That is, the law that the feudal government must operate under with respect to the land jurisdiction and the people of the land. We are owed all our natural rights and a republican form of government. 2. The corporate constitution, known as the Constitution of the United States of America, is built of articles of incorporation, a different kind of articles entirely. Amendments to this Constitution do not strictly require any ratification by the federal state franchises, and they only represent changes in public policy by the corporation, not any amendment of the actual Constitution creating the federal United States. This means that the 13th Amendment onward are not public law, only private law affecting the officers and employees of the United States of America, Inc. The existence of this corporate constitution is a direct result of the fact that the federal United States is a separate and, with respect to us, foreign nation. It is allowed to organize its internal affairs as it sees fit and to impose whatever laws it wishes to apply to its citizens within its international territorial jurisdiction. This is why the entire federal code, including the Internal Revenue Code, persists in calling birthright citizens of the continental United States non-resident aliens. I'm a non-resident alien? From the perspective of the federal United States, we are aliens when we enter their international jurisdiction, and we are either resident or non-resident in their federal states. 3. The municipal constitution is known as the Constitution of the United States. By now you are shaking your head and thinking, which United States? Continental, federal, or corporate? Corporate. The short answer is corporate. Just another form of corporate. This is the Constitution of the Washington, D.C. municipality, an independent international city-state run as an oligarchy by the members of Congress. It is an offshoot of the federal United States, which granted it a treaty similar to the treaty that the United Colonies granted to the continental United States, and which they granted in turn to the federal United States. Think of it like a set of nesting dolls. The global estate trusts chartered the United Colonies, which chartered the continental states, which chartered the federal states, which chartered the municipal city states. This municipal constitution is simpler than the federal United States corporate constitution and is loosely based on it. The citizens of the Washington, D.C. municipality and its franchises are all debt slaves, including the states of Ohio and John Quincy Adams. States of states. In addition to all these federal constitutions, there are also state-level constitutions. There are the original state constitutions, which are treaties, and there are the federal state constitutions, which are corporate charters, and there are the federal state municipal constitutions, which are corporate municipal charters. The Ohio state is one of the continental United States operating on the land jurisdiction of the United Colonies. It's a republic. The United States of Ohio is a corporate franchise of the federal United States operating the sea jurisdiction of the United States of the United Colonies. It's a constitutional democracy. The state of Ohio is a corporate franchise of the Washington, D.C. municipality, which is operating as an independent international city-state. It's an oligarchy operated by Congress. And just recently, the United Nations, Inc. bought all the DC municipal franchises and is in the process of renaming them so that the state of Ohio will be operated by the United Nations as Ohio. And the John Quincy Adams Estate Trust will be operated as public transmitting utility under the name John Quincy Adams. Look for the fraud coming to your mailbox soon. The Constitution v. a Constitution. Obviously, with all this semantic deceit flying from the fan, it is nearly impossible to carry on a sane conversation. Which United States are you talking about? Which state are you referring to? Which constitution? Which citizen? There's only one original equity contract tying any of continental United States to the federal United States, and it is doubtful that the entities currently representing the federal United States have any standing to trade upon that contract. As we shall see, the federal United States has been repeatedly bankrupted by British and European interests, and various ploys have been used by those same interests to fraudulently entrap the assets of the continental United States in these bankruptcies. Our point, there's a reason for the use of all these deceptively similar names. They have been used to promote fraud on a vast scale. That was part 5 of You Know Something Is Wrong When, an American Affidavit of Probable Cause. Next time, we will be going over part 6, the Civil War.